Hello and welcome to this short teach-in video, which forms part of a series of teach-in videos that the Tenant Farmers Association is putting together to provide some insight into some of those tricky issues that so often come up when we're dealing with landlord-tenant situations in agriculture. Now, in this session, we're looking at a big topic. We're looking at how to prepare for making an application for succession of tenancy, where that's available, either on the death or retirement of the previous tenant. And this is being recorded as at August 2022, so the information that reflects what we know at that time. Now, before we start, I should say that this forms part of a wider library of video information that's available for you to view on our YouTube channel. So if you want to go there, if you stumbled across this because you've Googled something on succession, then you'll see a lot of content on our YouTube channel. And if you can click on this subscribe button, then you'll be notified when new material is published. We're extremely grateful to Barclays Agriculture, who have been sponsoring our webinar and video content for a little while. So we're grateful to have them on board. So, as I say, we're attempting to cover a vast topic today. So don't expect to have too much detail because we're really only going to be able to scratch the surface. But we've got one of our expert advisors with us who's going to lead us through some of the issues to think about in terms of preparing for succession. So let me introduce you right away to Adriana Vaux, who's going to take us through those top level issues. So over to you, Adriana.
Good morning, everyone, and thank you for joining. Today, we're going to be talking about succession. There are two routes to succession. One is on death and one is on retirement. There are various pros and cons to each. However, generally, we always recommend that people look to prepare for succession on retirement, predominantly because this means that you have your family around you to support you and help you through the process. Whereas on death, you've obviously lost a very much closer loved one. This is a very stressful time for you, and then you're going to have to worrying about the very stringent criteria for succession and the stressful process of potential tribunal. So those are the two routes of succession. Next, you need to think about the eligibility. A potential successor needs to jump through many hoops in order to succeed to a tenancy. So firstly, you need to check with a professional that your tenancy is capable of succession and how many provisions are remaining. You then need to check whether you're eligible, and this can take years of preparation, so it's never too early to start preparing for succession. The potential successor needs to check whether they meet the eligibility, so they need to be a close relative. This could be a child, a sibling, or a spouse, or someone treated as a child. You then need to check to see whether you meet the livelihood criteria, which means that you need to be deriving over half of your living expenses from your work on the holding for the last 7 years. You then need to see if you are suitable. So do you have good financial standing? Do you have good health? And are you generally able to farm the farm well and have good business acumen? These are really important, especially going forward with the test changing in 2024. And then you need to see whether you are in occupation of any other land. This is important because if you have a tenancy, for example, of 5 years or more, which can derive around 2 fully grown men's wages, so potentially around £42,000, this could mean that that goes against you towards the criteria. It's fine to have a grazing license or a tenancy of less than 5 years. So going into a bit more detail about the livelihood criteria, this is something which a lot of our members ask many questions about and get understandably very confused because it is a tricky situation. So it's much easier for someone who's effectively single and working on and living on their family farm. So an easy example is if you have a farm cottage which you are able to live in on your parents' farm because you work on the farm and you don't have a spouse and you work full-time on the farm, this is pretty much the best way to meet the livelihood criteria. But if you're not in that situation, it doesn't matter. You need to start thinking about all your bills for your entire family. So you add up all your bills. So that's if you have children and you have a wife, all the bills for your family, add them up, and just to see if you meet over half of them from your work on the holding. And it doesn't just have to be a wage. For example, if you have benefits in kind. Now, benefits in kind are, you could have the farm cottage is given to you by your parents because of your work on the farm, or you have a farm vehicle, your fuel's paid for you, or you have your utility bills paid. That's all what's called benefit in kind for your work on the holding, and that all adds up and has a value. Now, if you have a spouse and they have a good job, you need to be careful what that money pays for. So if your wife, for example, is paying for all the food and the clothes of your family, that unfortunately will go against you in your livelihood criteria. So it's really important to see where that money goes. And if it goes towards the living expenses, you need to start trying to change your affairs so that, for example, that money is going to investing in the holding or is going towards pensions and savings. So it can take a bit of time for you to really change your situation to try and meet 7 years worth of years prior to the date of death or the retirement notice before you meet the eligibility criteria for the livelihood. And this does take a lot of forward planning and can take often years to sort out. So once you've checked all those, you then can see which route you want to take towards succession. You can either succeed formally or informally. It is always best to, even if you want to succeed informally, which is through negotiation with the landlord, that you must meet all the criteria, because you still will need to apply to tribunal, act as a safety net, just in case all negotiations with the landlord fail. So succeeding informally just means that you're negotiating with the landlord and they allow you to succeed without having to go through the process of tribunal. Formal succession means that you have to go through the tribunal, which is incredibly costly and stressful, but unfortunately a lot of tenants are unable to negotiate with the landlord because the landlord simply does not want them to succeed. So what you do is you can, if you're going for a retirement, a succession on retirement, you have the outgoing tenant, who's currently the tenant, has to serve a retirement notice on the landlord, giving him notice of retirement and nominating the potential successor. That successor will then need to apply for tribunal. There are very strict deadlines which you'll need to adhere to, and we provide some very good guidance notes which will give you a really good idea of those deadlines, because it's too much to talk to in this video. So have a look at that guidance note and they'll give you all the deadlines you need. So you apply to tribunal and the tribunal will require an application, and this is a very long form which you'll need the assistance of either the TFA under our TFA Plus scheme or another professional to help you with. Whilst you're doing this, you can still carry on negotiations with the landlord, and it's always advisable to, because the judge at the tribunal want to see that you're making every effort to try and negotiate to reach a settlement. But this will need to take place alongside any application, and the judge will be able to discuss and talk to the parties. But whilst this is going on, the landlord will also be able to make an objection. And he'll also have strict deadlines to do this.
All right, well, I think we'll have to stop your introduction there, Adriana, because obviously there's quite a lot to take on board there, and you've rightly referred to the guidance notes that the TFA produces that has got a lot more information in, particularly on things like the livelihood test. But just on the livelihood test, you mentioned there was a 7-year period you've got to do those calculations for, and I've got to show that I've taken the majority of my livelihood from farm work on the holding for those years. Do I have to comply for all 7 years?
No, George, thank you. Technically, it's 5 out of 7 years. However, I always advise clients and tenants that we should prepare for 7 years, because usually the landlord does ask for full 7 years, but it is only 5 years that you need to show, and these do not need to be consecutive years.
Okay, thanks for that. So, I mean, you've obviously been involved in a large number of discussions with TFA members and dealt with applications for succession, and you've seen how landlords react to those applications, and you have experience of the tribunal process. So what issues do you routinely see thrown up by landlords who want to delay the process or stop a tenant from succeeding?
Yeah, so sadly, I see many of these instances, and I'll just explain to everyone that when a tribunal is applied for, a regional judge is assigned to your case, and the judge will participate in meetings with your chosen professional and the opposition's professional. And these meetings are what's known as case management conferences. And the judge would like to see parties attempting to negotiate and make a settlement after these case management conferences. And this can take huge amounts of time. And the judge will make what's called directions, which gives deadlines by which parties must negotiate by. But sadly, what I often see is that the landlords are not willing to engage, so time keeps ticking on. And by the time the deadline within those directions is about to approach, nothing further has happened. So the landlord requires another what's called a stay, and this can be another 3 months. So that's another 3 months gone. And again, sometimes in one case in particular I'm working on, we've had about 4 different stays, and sadly we are no further on because the landlord is not willing to engage. And I've found that the landlord protracts negotiations because this means that the tenant is still having to pay for the costs of potentially multiple professionals, which means that the costs are creeping up, and I'm sure that the landlord is hoping that the tenant will have to pull out because they simply cannot afford to keep going on for months and months paying a couple of professionals. So that is one big tactic that I sometimes see, and it is really quite frustrating and worrying for the member involved. So in terms of high volumes of cost, this clearly is a big issue, and it is particularly prominent when a landlord gets difficult. And for example, a landlord could have to engage an agent, a solicitor, and they choose a barrister and various experts as well. And therefore the tenant has no option other than to engage multiple professionals themselves. So the costs just rack up, and members need to be aware that to do a succession case through tribunal will cost tens of thousands of pounds. And unfortunately, it's not unheard of for it to reach £50,000 plus, which is why one of the most important issues that you need to think about when you are planning for succession is that you know that you have the funding in place, whether this is self-funding or whether you have an insurance in place, such as the TFA's Farm Business Protector Insurance. It is vital that you look at how you fund tribunal and succession before going forward.
Okay, that sounds quite scary, Adriana. Obviously, people do need to have that guidance. So it's good that you and other TFA advisors are around to provide that guidance. Now, you mentioned in the livelihood test about benefits in kind. How do we differentiate between benefits in kind that are provided simply because the potential successor is a child of the deceased or retiring tenant and are just being looked after by their parents, as opposed to getting those benefits in kind in return for their farm work on the holding? Would it be sensible, for example, maybe to put some documentation in place?
Yes, that would be a really sensible idea in planning for succession. And unfortunately, it's something that I'm yet to see in any of my cases. It would be incredibly important and helpful, not just for yourself, but for the tribunal going forward, to see evidence to really show the differences, as listing down by the current tenant what they have given the potential successor for their work on the holding, but also during the application, the potential applicant successor will have to evidence what exactly are the benefits in kind, and this will have to be done by statement, which will have to be signed as a promise. So there is no hiding, and you do have to be as truthful as you can when separating out what you have for your work on the farm and what you have for just simply being a child. And the tribunal will take a look at what is reasonable. Have you spent enough time working on the farm to make up for the value of what you are being given? So it really is a very scrutinizing area, which the tribunal will look at incredibly closely. So it's important that everything is documented and that you're as accurate as possible in telling us what you get for your work on the holding.
Okay, and finally, sometimes a landlord might offer a farm business tenancy instead of agreeing to a succession. Are there any circumstances that it might be a good idea to consider that instead of pursuing a succession?
Well, yes, there actually are. And as scary as it sounds, moving from an AHA to an FBT, there can be a huge amount of positives for doing this. So, for example, a landlord will only offer an FBT because they are absolutely desperate that they do not want the tenant to go onto an AHA for various reasons. And because of the landlord's desperation to get a tenant onto an FBT, a tenant will be able to push back by asking for something big. So I always, for example, recommend that you perhaps get another member of your family onto the tenancy as a joint tenant. This is especially advantageous if your current AHA tenancy, you're using the last succession, so there's no more successions left, and you work with one of your children who is showing real potential and wants to carry on farming after you, or perhaps you have someone in that position but they're just simply not going to be eligible going forward. And therefore they would have no chance of succeeding. So that is a big advantage to having an FBT. An FBT also, we're so used to seeing it used as a very strict and rigid template agreement, but one of the purposes of an FBT is to be very customizable and flexible. So anything can be written to an FBT. You don't have to have an FBT which mirrors the current up-to-date FBTs. You can have ones with AHA provisions, such as following the AHA rent review provision, fairer repairs, such as the model clauses, and then, as I say, you can bring in another member of your family potentially. So this would be a huge benefit to some potential successors.
Okay, I think we are going to have to draw things to a conclusion. There clearly a lot to think about, clearly a lot of advice needed at that time. Clearly can be quite stressful and quite expensive, but thanks, Adriana, for running us through those issues. So we hope that you have enjoyed and got something out of this short teach-in. And as I say, watch out for the others that we've got in the series, and don't forget to look at our YouTube channel to get more information from the Tenant Farmers Association. And if you're watching in advance of our autumn and winter 2022 webinar program, look out for some really exciting webinars that we've got coming up. So we've got Baroness Kate Rock, who is chairing the Tenancy Working Group, and she's hopefully going to be coming to us at the beginning of October to talk us through her report, which is due out next month in September. We've also got a deep dive on issues around carbon and biodiversity net gain and how they play within agricultural tenancies. We had an earlier session with Charles Callett from Harper and Philip Mead from Davis Mead, and they're going to be coming back to do a deep dive into that issue for us. And then before the end of the year, we're hoping to have the DEFRA policy team back to tell us what to expect in future policy for agriculture going forward into the new year. If you're not a member of the TFA, you can get advice, information, and support on a one-to-one basis from Adriana or any of our other TFA advisors. Annual membership is currently £220 per year, so it's very inexpensive. And you can join by going to the TFA website and clicking on www.tfa.org.uk, and there's a join here button that you can go to get further information. So thanks again to Barclays for their sponsorship of this series, and thank you so much to Adriana and for you for watching. Goodbye.
Goodbye.